Judge knocks director's disqualification application period from 10 years down to 4. This is a case of Secretary of State versus Mr. Stan, which was part of a post yesterday about the period of director disqualification. And the purpose today is to just point out a few salient points that come from this case. It's quite an interesting little case, and there's some interesting little points. One caveat though, this is not legal advice, not to be treated as such, not to be relied upon as such, general information purposes only. Now, in this particular case, just to recap, Mr. Stan was the director of a company. He applied for a bounce back loan. He applied for a £50,000 bounce back loan, and he got around about £20,000 too much. And what the Secretary of State did was the Secretary of State applied for a director's disqualification period of 10 years. And the judge basically said, no, we don't think it should be 10 years, or I don't think it should be 10 years, it should be 4 years. And the rationale behind that was that it was not deemed to be in the sort of middle bracket of serious level of misconduct. The judge accepted the fact that the director had been careless, that there had been a fairly serious lapse in relation to the completion of the application form for the bounce back loan, basing it on estimated turnover when the director, Mr. Stan, should have done it on the basis of actual calendar year 2019 turnover, and that the estimated option shouldn't have been utilised. But what the judge said was that the conduct of the director, bearing in mind that the bounce back loan had not been, even though the company got too much, it hadn't been used for purposes other than the benefit or the economic benefit of the business. There was no suggestion that the director had hooved up the cash personally, for example, as in some of the more egregious sort of cases of bounce back loan misconduct by directors. But there were a few other points that you can glean from this. The first thing, of course, is that this was a case where the director took the matter to court in terms of it was contested. So it wasn't simply a case, as many directors may fear, that the Secretary of State, through the machinery of the insolvency services usually, the Secretary of State wasn't simply able to snap their fingers and say, we will disqualify you for 10 years, because that's not how the system works. The way the system works is that the Secretary of State applies or suggests to a director that they think that the period of disqualification, if they think that there should be a period due to unfitness, misconduct, whatever it might be, should be X number of years for the sake of argument, with the lowest bracket being 2 years, the highest bracket being 15 years. So they make a suggestion. Now what happens in most cases is the directors tend to come to either a deal or they roll over or whatever, but it's dealt with by consent, by what's known as director disqualification undertaking. So it's dealt with by consent, i.e. agreement. What happened with Mr. Stan was he said, no, I'm going to contest it, and it's absolutely within his right, and indeed it was to his benefit from the point of view of the period of disqualification, because it was less than half of what the application was for. So the point is number one, the Secretary of State has to apply. It's not simply the decision is not the decision of the Secretary of State. The decision is the decision of the court, ultimately, particularly obviously in a contested case. That doesn't mean that you can't negotiate with the Secretary of State and seek to reduce the period if you think that the Secretary of State's got it wrong. The other point was that because the Secretary of State was asking for a period of 10 years, which is reasonably standard in many cases where the Secretary of State thinks that a director is guilty of some misconduct in either applying or using a bounce back loan. When I say reasonably standard, I mean it's 9-10 years is very, very common in terms of the period of time that you will see in the director disqualification listings, which are dominated by undertakings, not by court orders. 9 or 10 years is very, very common, particularly in exaggerated turnover cases, and this was an exaggerated turnover case, Secretary of State versus Mr. Stan. Now, but what the court said was that if you are going to allege serious misconduct, that's the Secretary of State, because the burden of proof is on the Secretary of State. Then you, i.e. the Secretary of State, is going to have to properly particularise the case of whatever the case is based on, whether it's based on dishonesty, whether it's based on fraud, whether it's based on some other kind of misconduct. Now, and this very much appears from the way the judgment was worded to have been the problem that the Secretary of State faced in pushing forward for a 10-year period. And one of the common things that the judge said, which if for those people who see judgments routinely like I do, is that the idea behind the court system, which is an adversarial system, it's not an inquisitional system, it's adversarial, it's Secretary of State versus the director, with each side putting their best case forward and then the judge making a decision based on what the cases are put forward. What the court said was that the Secretary of State has to put forward the case so that the director knows the case that he or she has to meet. I mean, this is absolutely routine, bog standard stuff for people who practice litigation routinely, but the point ultimately is it's about being fair to the respondent in litigation, that the person who is making the application has to put forward the case and has to properly set out the case that the other party has to meet and respond to. Otherwise, you have a situation where the director who was responding to an application for disqualification doesn't know what they need to respond to and what the allegations are. And that was a key point, and that ultimately was one of the key reasons why from what we can gather, as to why the judge pushed down the period right down to 4 years. I mean, less than half what the Secretary of State actually was applying for, given the fact that the Secretary of State was after 10 years. So, but the other point, of course, that this demonstrates is that if a director needs to be a little bit cautious in terms of the benefit of obtaining independent legal advice from typically a firm of solicitors in these matters, or certainly somebody authorised under the Legal Services Act, is undoubtedly key. But it highlights that the Secretary of State doesn't necessarily always get it right, and that the matter is not set in stone, and that if you genuinely feel that there's been an error, there's been some unfairness and so on and so forth, that you can do something about it. You do not simply have to accept what the Secretary of State says. Questions, queries, concerns, give us a shout. Winner Insolvency, Inside Out.